is a Star. It's a double-sided hit for them. Their follow-up to Hot Fun in the Summertime. Wow, that seems like ages ago, doesn't it? Especially with all the snow warnings we have for this evening. We also heard before that a group from England that you have to see live to really appreciate the young tradition, a little Christmas carol thing. And we're going to head right now into Speak Out. And Spencer Cox isn't with us today, but we have an able substitute for you. Don't forget, at 9 o'clock, we're going to do something very special, so tell your friends all about it, okay? We're going to fade out now with Little Rhinoceros, Apricot Brandy. For Speak Out with David Patinsky filling in for Spencer Cox this evening. And let me remind you in front, the number here is 878-1023, 878-1023 if you have any questions about civil liberties and associated problems. Good evening and welcome.
Thank you, T. I'd like to start tonight's program by simply informing the WDAS FM listening audience about a recent victory obtained in part through the help of the ACLU and its volunteer council in connection with the police bust of apparatus employees and confiscation of apparatus posters, including those of Jimi Hendrix, and buttons which the police found offensive. I might say that to some people a bust of a few employees at an apparatus store or two might not seem too significant, but I think anyone who's ever come in contact with unrestrained police force can tell you that where the police do act illegally, as they have now been found and held to have acted in this case, and where their illegal actions do not go curtailed or are not curtailed by courts, they proceed to engage in further unrestrained and illegal acts against other establishments which they view with distaste because of the ideas or the materials which they are distributing. In this case, counsel for apparatus and later counsel for the ACLU, as a friend of the court, asked the court to enjoin the police raids on apparatus and the confiscation of materials because there had been no prior determination of obscenity. And what I mean by that is that the police officials didn't go before a court and have the court decide that what they were confiscating was obscene before they seized it. And they didn't go before a court and get that determination before they arrested the apparatus employees for selling obscene material. In short, the police acted illegally. The result of the suit was that the police were enjoined from further arrests of apparatus employees, further confiscation of buttons and posters and other materials sold by apparatus, unless they did in fact obtain a determination of obscenity before proceeding to arrest and confiscate.
Could the excuse me, Dave? Could the employees do anything to like retaliate in any way, shape, or form because like false arrest or anything of this nature?
No, in this case, I don't think they could for this reason. The court did not find that the police acted in bad faith, and since that is or would be a prerequisite, certainly, to any suit for false arrest and harassment under the Civil Rights Act, it simply doesn't exist in this case. I might add a further obstacle would present itself in view of the fact that even if there had been bad faith, the only people that the employees could sue would have been the officers themselves, who probably don't make that much money. They couldn't really pay the judgment that was obtained.
Under orders anyway, right?
Well, if they acted in bad faith, that would not be an excuse. But the point is, the court found that they were acting in good faith, and based on that, they have no further action. I might add, though, that the important thing is that the principle was completely vindicated, and a result of that is, of course, that the apparatus continues to sell its buttons and its posters, as do many other establishments in the city. I think this is, again, a very important victory because we have seen recently shocking displays, or at least what appeared to be shocking displays of excessive police conduct, not so much here in Philadelphia as in Chicago. And it's very important to let the police know that we're watching them just as they're watching us. And if they step out of line, they're going to have to justify what they do. And I think it's a very, very helpful thing for them to know that they're being watched.
Well, the number again here is 878-1023. This is Speak Out on WDAS FM in Philadelphia with David Patinsky and myself, T. Morgan. If you have a question or comment, I suggest you call right now because the lines are open. Anything else happening in the city? Whatever happened with the Nixon and the flag thing? Did that ever, has that come up yet, or is that still like pending? Or?
I'm really not aware of what the status of that is at the moment. I think something else that ought to be known by your listening audience, however, is the fact that in connection with the Powelton Village Drexel demonstration case, that the attorneys from Community Legal Services, who were representing the Powelton people and demonstrators, obtained a writ of prohibition from the Supreme Court of Pennsylvania against Judge Weinrott, who was sitting on this case, to have him excused from sitting on this case because of prejudice. And this has not been decided, but there will be a hearing on it because of the substantial averments with respect to his conduct in this case. He is, in fact, even challenged the right of one of the attorneys, two attorneys, to even appear and represent the people of Powelton Village, even though this attorney has been admitted to practice before all the courts in Pennsylvania pursuant to the Supreme Court rules. So this will be something to keep our eyes on because I don't know whether too many of you are aware of the fact, but there are certain judges in the Court of Common Pleas located in City Hall, and I don't want to seem to attack in any way or form all of them because I think we've had far too much of that from the mayor and the police commissioner in connection with sentencing. How the mayor knows that those people who tragically killed that shop owner the other day were doing it because they did not fear being punished by the law is, of course, pretty mysterious to me. I didn't realize he was a seer. But in any event, the point remains that there are some judges, like Judge Weinrod, who seize on all of these cases which we like to consider liberal causes and then express their very conservative tendencies. Judge Weinrod, of course, seized on the Police Review Board case in the past. He has tried to get the I'm Curious case until it went to federal court, and again, he was on this case, even though it's my understanding that when a special case comes in for preliminary injunction, it's supposed to be assigned to the motion judge and motion court. But Judge Weinrod is all over the place. In any event, I'll take the first call now. Hello?
Well, it seemed to be having trouble with the phones or
Well,
something.
somebody may have called and hung up during my rather discursive speech on Judge Weinrod.
I'm concerned that it's not plugged in. I'm not sure that it is.
In any event, I would
My engineer assures me that it's
hope
plugged
that the
in.
listener who did
Good.
call will call back right away, and I'll take his call. Here he is now, or she.
Can get out of a Roxy contract. I know a person who signed when he was 17.
Mm-hmm.
Now he's completely against the war, and this is war, he's against all wars. And it seems like he's really, caught up in Roxy, and he can't get out of it now.
Well, how old is he now?
Let me see, he's 19 now.
Well, I would suggest that first of all that he get a lawyer. If he can't afford a lawyer, certainly there are many agencies in the city like the ACLU that would help. I do know that as a matter of contract law, wholly apart from any other constitutional rights which might be involved or might not be involved, that as a matter of contract law, he was not of age to sign that contract at the age of 17. I don't know if anyone has ever tested enlistment contracts, ROTC contracts, reservist contracts, which were signed before the age of 18 on the basis that they were minors. It might be a very interesting point, and I would certainly recommend that your friend see a lawyer in connection with that single aspect alone.
All right, thank you.
You're welcome.
Okay, if you have a call, 878-1023 is the phone number, and the lines are open.
Right. That last question, of course, raises a very interesting point. Really never had hit me until the listener asked the question that normally an individual under the age of 18 is not really considered to have the authority to sign a contract which is binding on him, whether it be buying a car or anything else. And the last listener asked whether his friend, who had signed a ROTC contract at the age of 17, could get out of it.